There's a status hearing in the state-level case against Illinois' gun and magazine ban, and that's going to be in Macon County over in Decatur this afternoon. You've got State Representative Dan Caulkins and others represented by Jerry Stocks who are advancing their case standalone after the Illinois Supreme Court denied Attorney Thomas DeVore's motion to consolidate his three cases with the fourth case out of Macon County. So DeVore's three cases are combined. Those are two out of Effingham and one out of White. He's also got subpoenas that are pending there and motions to quash those subpoenas. But the Illinois Supreme Court's not combining those three with the Macon County case. And the Macon County case has a status hearing set for today. I talked with Jerry Stocks a few days ago, and he's the attorney representing Dan Caulkins, state representative. And he gave a little bit of an indication on what to expect. So here's Jerry Stocks laying out some of what could possibly come up today during a status hearing on their challenge of the state's gun ban.
Well, March 3 is a status hearing, and we will have independent motions from both sides on file and briefed by then. And then if we can arrive at the content to a form of order approved as the form, we can conclude matters in the circuit court. And so there's still those issues ahead of us there. By the order of about 10 days ago, it's indicated what we think we can put together. However, that order has to recite many findings, specifically in a final judgment under prior precedent. We need some specificity in that order to inform and support jurisdiction before the Illinois Supreme Court. It is anticipated that judgment will be entered in favor of plaintiffs in Macon and against the defendants, which would shift the burden of appeal to the defendants. And if they so elect, and as I obviously expect they would. So that's how we see things unfolding. But our next step is to assure that the final order in Macon County has the requisite specificity. I believe it's the Sharon case, which is a Second Amendment case of a few years ago on declaring the 1,000 feet within schools facially unconstitutional for purposes of that criminal prosecution. It has some requirements regarding order specificity. So that's the next level of what we'll have to cast an eye to as we progress through this process.
Again, Jerry Stocks, the lawyer representing State Representative Dan Caulkins in that case in Macon County with a status hearing today. And the Macon County case only has, a few named, but they're also representing law-abiding gun owners of Macon County, a kind of loosely associated group of sorts. And there's been some consternation between DeVore and Stocks as to the approach. DeVore has thousands of named plaintiffs on his cases that have temporary restraining orders. That includes gun stores, and they can buy and sell in between those named plaintiffs and gun stores. Stocks, though, he says his aim is to get a quick resolution so that there's a temporary restraining order or some kind of injunctive relief for the entire state. And the arguments they're using aren't necessarily Second Amendment arguments. They're the arguments of equal protection under the law, saying that you can't carve out certain rights for certain people and not give those to others. And that's an argument they're advancing. But they're also advancing arguments of special legislation, different from what DeVore's are arguing as well, but more from Jerry Stocks on the kind of intricate detail here on what to expect here in today with the status hearing and moving forward.
Well, if we have the respective sides have indicated that their opinion that accuracy firearms, the holding and accuracy firearms by the 5th District controls the Macon County Circuit Court. If there is an agreed order as to form, even as early as March 3, that could be submitted to the court, and that order would have to yield a judgment in favor of plaintiffs declaring the statute unconstitutional for one of two or both specific reasons. But the Illinois Supreme Court be able to achieve appellate or direct jurisdiction on review. It's Illinois Supreme Court Rule 302A1. And so these measures, everybody says things are moving so fast. It is still a process, and there are still issues to work out. It could happen as soon as March 3, or it could not come together and the motions would have to be set. Well, again, we're in the trial court. Nothing's to the Supreme Court yet. There are many steps that have to occur before that happens. So if arguments are necessary to get a judgment in the circuit court, then the circuit court will have to set when those arguments are. If there is an agreed order as to form, there will be no need for argument.
So we'll see what happens. Keep you updated on that, and we'll bring you those updates Monday morning here on WMAY. I'm Greg Bishop. Follow along, Bishop on Air on Twitter, Facebook, YouTube, where you can see clips of interviews and call-in segments and more. So again, just follow along, Bishop on Air, and we can connect that.